I'm a job loser of 2016 selection process.
You are?
I'm a job loser of 2016 selection process in 11-12 class. My lord, what happened, my lord? Parallelly, my lord, I have participated in upper primary selection process. The selection process, I have been come under the provisional merit list, my lord, provisional panel. I was called for the interview first phase of counseling. The first phase of counseling, which was held in the possibly in the month of November 2020.
Mr. Tomorrow certain matters are fixed.
Yes, I think.
Similar matters.
Then-
Obtain instruction because you have issued a notification fixing date of counseling
Yes.
on 11.
11th of June. Well, this is the situation, my lord. I was called for the counseling in the first phase of
Whether it is a similar matter.
yes.
Those matters I will have to check. All of them are slightly different. Here in the representation, the petitioner is saying that though called, I did not go.
Yes, because I
So
was at
then-
that time I was working in the 11-12
Here,
classes, my
but
lord.
the petitioner
I have no
that the employment.
But you are called for this counseling.
counseling. My lord, at that time I was working. My lord, I was in hope that I shall be succeeded in the Boishakhi Bhattacharya's case. But lord, subsequently, Supreme Court in the month of April, my panel has been cancelled. I have been jobless immediately after I made a representation. I may be facilitated for another phase of counseling. As because I am in the panel, provisional panel, in the merit list, I have fulfilled I have crossed all the hurdles. And after that,
Why you did not appear in the counseling?
my lord, at that time I was working in 11-12.
Then-
My lord, ongoing selection process is ongoing. I'm only praying I may be facilitated for the another phase of counseling. That much. Whether, my lord,
Since you have lost the job, that's why you are now praying for.
my lord, even Honorable
But
Supreme
my
Court
rule
is saying,
specifically states
Honorable
that the-
Supreme Court is good. Dada bol.
But Honorable Supreme Court has said that only those candidates who can participate who are not tainted.
I am not,
How court will consider that you are tainted or untainted?
my lord, I am still working. They have sent me the
Maybe, but you are tainted or untainted. How could whether your name was forwarded by the DI to the
yes. I am working, Lord.
Then-
I have stated in my writ application.
because tainted candidates cannot work
No,
till
no.
31st of December.
Yes.
Only untainted candidates can work till 31st of December. He is working in the school now.
I have stated in my application.
Yes, Mr. Dr. Patro. He is not untainted. Had he been, he is not tainted. Had he been tainted, then he would not have been permitted to work till 31st of December.
No, I'm not saying that he was tainted, but he was absent. And the rule is very specific that the absentee candidate will not be given a second chance. So, that apart, the method in which, the manner in which we are carrying out this counseling, it is actually pursuant to the direction of the Supreme Court. The vacancies were specified, the candidates, the panel and the waiting list, everything was placed before the court. And everything is restricted to that panel and that waiting list.
But petitioner was an impaneled candidate.
He was,
He was there in the panel.
But there are also many matters before the court where they are not even in the panel or the waiting.
But where is the legal bar?
Bring them back.
Where is the bar? Because he was in the panel. Petitioner was in the panel, and that panel was placed before the court. And petitioner is now seeking because he has lost job in connection with the selection process which was conducted by the commission. Now, why petitioner will be debarred?
Now it is too late to accommodate him. If I start accommodating, let me be more clear. The division bench directed me that we have more vacancies than candidates, so all candidates should be accommodated. But though we had more vacancies, when we put them into the categories, then we found that in certain categories there were excess candidates because the panel, my lord knows, is 1:1.4. So 0.4 excess is always in my hand. Now that we have not managed to give accommodation to all, the court is also coming down very
No,
heavily. upon
applying the ratio
vacancy.
of 1:1.4.
Yes.
That is against one vacancy, 1.4 candidates can participate.
So 100
in the counseling.
vacancies, 140 candidates.
Yes, right. 100 vacancy, 140 candidates. If applying this ratio, petitioner comes within the zone, permit him.
My lord, that can only be permitted.
Permit him.
That can only be permitted after I have exhausted all my candidates in the petitioner's category. Because
Because it was your selection process, Dr. Patro, which was found fault by the division bench and the commission. So some responsibility you have to shoulder.
my lord, but I cannot.
The petitioner has lost the job for which petitioner should not be blamed because he is in the list of untainted category.
No. Why did everybody lose their
So
job?
therefore, instead of going into it was whose fault, since the petitioner.
But I will also not take the petitioner
But
as
the-
100% innocent. The
Why?
Supreme Court did not. Everybody lost their jobs.
But
They were
the selection
untainted.
process was conducted by the commission.
Yes, it was conducted.
That selection process was found to be a faulty selection process.
As a result of certain.
So if this was yes, so therefore permit at least those candidates who are coming within the zone of consideration, applying 1:1.4 ratio.
They missed their
But
chance.
because they are not,
Their
they are not.
vacancies have been, my learned friend himself has submitted that he was called in the first phase counseling.
Yes.
Now we are conducting the seventh phase. That vacancy probably has been taken away by somebody else.
But he was an eligible candidate.
Very well, let me take instruction. Let me come back tomorrow because other matters my lord has also fixed. Let me check the facts in those records, in those matters also, and I'll come back to that.
No, this matter was filed on 30th of April 2025, and the date of counseling is 11th of June. Today we are on 9th.
No, that was notified only. And when this was filed, there was no.
And that is the last date of counseling, perhaps.
No, it's not. It's not. It cannot be.
Permit the petitioner.
No, kindly do not.
No,
I
no,
have
Dr.
few-
Patra.
That a few thousand candidates to accommodate. Before this court, there are more than 500 candidates probably. And my lord is already refused in so many matters.
No, they are
The
not
matters
coming
are
out.
pending. I'm not saying that finally it has been decided.
They will permit him. In the meantime, you exchange affidavits, let the writ petition be decided.
Why let me also.
And do not, if petitioner is found to be a successful candidate, don't appoint him in the meantime till the decision is till the next decision is taken on the next day.
Can I make one second? Since this seventh phase of counseling has already been notified, all the candidates equal to the number of the vacancies that we saw for the council. So if I give the decision on seventh phase, then one candidate will have to go on. That also not be fair.
But that is not in dilution of merit. I am not saying so. Maintaining the merit position you allow him.
The fact that he was called in.
If by way of applying the merit position, if somebody goes, what can be done?
I thought my learned friend was absent. My learned friend.
Yes, because there was a certain circumstances, Mr. Dr. Patro.
No, but-
I'm not, this court is not, so this court will never direct that in dilution of merit, permit him.
No, I'm not saying that.
So in terms of the merit, if petitioner comes within the zone of consideration, applying 1:1.4 ratio, permit her, him or her.
Candidates cannot take a chance and then come back and put the responsibility.
What can be done? Who is to be blamed? Who is to be blamed for that?
No, but he was called.
The state government and your commission is to be blamed for that.
My lord, may I make one submission? May I make one submission? But one thing is required to be understood. Blaming each other will not help.
Yes.
We will not take the.
So special situation requires special situation requires special consideration, Dr.
No,
Patro.
but the facts and circumstances are not suiting a special situation.
Where is the merit list?
May I complete, my lord? May I?
Yes, just a minute. Where is the merit list?
Yes, my lord. My lord, merit list I have annexed page 21. My lord, SC female, past SC female, then my lord, page 22, serial number 67,
Page 22.
page 22,
Yes, name of the petition is there.
yes,
Serial number
serial number 4 from upwards, yes, 67, Mukti Vishwas,
67. Yes, female candidate,
male female, my lord, it is male female,
male female.
and also in general category. Page 23,
Where from you are getting general? Male female, right? Male female.
female, my lord, page 23, female, SC female,
Page 22. Yes.
page 23, serial number 12, my lord, serial number 12, female, SC female, Mukti Vishwas. And also, my lord, page 21 is a general candidate, also in the general list also.
Page 23. SC female.
SC
Then where is the marks position? Female TET weightage academic marks.
82,
Then
total
point
marks 82.
PT marks. Then total marks 82.
82. 82,
Rank, what is F212? What is F212 rank?
F stands for female,
female,
2 possibly stands for SC.
SC.
And 12? SC12 rank.
General, I am also in general category.
Male and MF means male female. Male female 2, that means civil caste,
Yes.
SC,
SC.
and then 67.
Yes. And also in general list. Serial number 21, also in general list. My lord, your lordship, if your lordship page to consider page 24.
Yes.
I have, my lord, page 24, serial number, first phase of counseling notice. My lord, 1514, general candidate. My lord,
1514.
1514. General candidate. I have called for as a general.
Male female 1.
And female 1.
1. General. 1393.
1514.
1393.
Yes, yes. Their
1393.
Yes,
Your rank is 1393.
yes. And when
So under three categories, you are ranked 67, then F to 12, then male, female 1393 general.
three categories I have in the panel. So therefore, I have called for the first phase of council. I have appeared as a SC candidate, but obtained better marks, and I also considered as a general candidate too.
But if you are a tainted candidate, then you are not eligible.
There is no question. I have stated in my application I am working. I have stated in my application I am working in the school. Lordship passed and direct
Regarding this issue of tainted, untainted, where you have made averments.
7 or 8.
I have stated.
7 or 8.
Because tainted candidate has no right to participate, as decided by the Honorable Supreme Court in the order judgment dated 3rd April.
Yes, yes. My lord, kindly consider page 9, page 5, paragraph 9. Page 5, paragraph 9. My lord, 1, 2, 3, 4, 5, 6, 7. 1, 2, 3, 4, 5, 6, 7. 9th line. Even the name of the petitioner is within the list of not specifically tainted, published by the WBCSC. Accordingly, petitioner is. I have stated in my application. When I filed my lord GI, not specifically tainted.
Any list has been published that not specifically tainted.
It was published in the public domain. That means in our website that I would have to check.
But because in other matters also it is being submitted that those candidates who are identified as not specifically tainted are being permitted to work till 31st of December.
Yes, that was allowed. That was the direction of this.
So there must have been a list prepared by the commission
Yes,
based
and
on.
it was circulated amongst the concerned officials.
But since the
whether it
petitioner
was
is being permitted, to work till 31st of December, in that event, petitioner it can be presumed that petitioner might have been in that list of untainted candidates.
issue, I will request the court that the court need not worry about it. If we find that the candidate is tainted, we will not. If we find that untainted, we will carry out whatever order comes from the court.
Yes.
But before the order comes from the court, may I just make two submissions?
Honorable petitioner is seeking a writ from my lord. Yes. Yes.
Firstly, the petitioner actually lost his job on the 22nd of April 2024, when the special bench, the division bench, set aside the entire selection process. Sitting tight for such a long period of time, hoping for the best. We always advise that you be prepared for the worst, and you are hoping for the best. We called you for counseling at the appropriate time. We did not debar you. You still sat tight, even though the Supreme Court had already reached its fag end of the hearing, or maybe it was reserved.
But there is an order of stay by the Honorable Supreme Court.
Yes, there was. But if you are hoping for the best and you are letting opportunities go, and then at the end, when you do not get the best, when the worst happens, you want to come back and unsettle a position where candidates who were already, this proceeding is also as per a division bench direction, which even there were several appeals against it, which were all dismissed by the petitioners, not by the commission. We carried it out. Now,
No, but the court is not saying that without following the direction of the Honorable Division Bench, you permit her or him to participate. But if petitioner comes within the zone of consideration in terms of merit,
but can-
without diluting the merit position, if petitioner comes within the zone of consideration, why petitioner will not be,
Candidate chose
petitioner will be
not to
left out
come.
considering the plight of the petitioner, Dr. Patro.
Not to come, the candidate was not thinking about what might happen. He did not think about the negative side. And now to make our process topsy-turvy at such a late stage, when we are at the 7th phase of counseling, the waitlisted candidates are getting the opportunity of getting employment. They are also unemployed youths. They did not run away. They remained with throughout the entire process. They were not happily working. They went through the entire process of litigation for 10 years almost. Now at the brink of getting employment, if I allow absentee candidates, a candidate who was called in November, is now wanting,
But how a court can shut the door of in front of this candidate who has lost job due to the misdeeds of the commission?
maybe, but we did not debar the candidate from,
It is not that, Dr. Patro, that the candidate has approached this court after losing job because of the fault which is attributable to that candidate.
no, in that situation, possibly it would not be open to him.
See the position. This is special
And
circumstances.
Discuss, let me come back, because since the petitioner was a multi-ranked candidate, against which vacancy his call was, he received the call, that I will have to check. That I will have to check. Let me come back tomorrow with some
No, Dr.
instructions.
Patro, today I will keep direction for
My- Kindly do not, kindly
Sure.
speak tomorrow, my lord. Because against which vacancy he was called also, then let him disclose the facts. Which vacancy was he disclosed? Why is my learned friend, he has not even annexed his intimation. His call for counselling, he has not intimated.
Yes, I have annexed.
I am
Page 24.
No, intimation.
Where is the call for counselling? Where
Page
is that
24.
document?
Page 24, first phase of counseling. First phase of counseling.
Page 24,
Page
Bosho.
24.
No, this is the list. Where is your intimation showing the date and time when you want to come and participate? Against which vacancy, against which roster number you were called?
No, court will direct that if he comes within the zone of consideration, he will allow him, otherwise not.
Yes.
My lord, if that order is passed, I will have a few, maybe thousands of candidates to entertain. All 9, 10, 11, 12
If
candidates
necessary, you have to extend the time.
extending
You have to
the
extend the time.
vacancies. I'm already facing a contempt proceeding where the court is coming down very heavily upon the commission for not being able to accommodate all the candidates.
You will
Now it
take,
might start-
you will take this point before the contempt court that the regular bench is passing these orders. What can be done? On merit.
No, I'm not managing.
Yes.
What I have not managed to complete. The thing, the
Regular bench is passing this order. What can be done?
I will have more candidates there. Vacancies have been given to other candidates. In this case,
No, I am not saying that in dilution of merit, you will permit him or her. But permit the petitioner if she comes within the zone of consideration.
my learned friend has come today before the court asking.
No, not today. This writ petition was filed 30th of April.
Today the matter is being heard. My learned friend has also not brought the list of vacancies. That is in our website. Then we could have identified that whether at all pure science there are still vacancies left, whether any candidate is being called. Out of 300 odd panels, at least 200 panels are exhausted. Only
Where is your first counseling letter?
My lord, first counseling letter I do not have annexed. My lord, page 24, that is the communication, that chart.
that is the panel.
There is the panel. There is no communication. Page 24 is the panel where your name is appearing at 1514.
First phase of counseling.
Yes, male, female, general category 1393. Where is the communication that you are asked to participate in the counseling? Where is the statement in your writ petition?
My lord, so far communication I do not receive from my client.
But where is the statement that you have been asked to participate in the counseling?
Yes, that I have.
Where it is?
On first paragraph 9, your petition submits a recruitment process upper primary is still going on and petition is completely completed by the name of the petitioner duly in provisional panel by the WBCC and petitioner has been called for first phase of counseling. I have stated in my application. First phase of counseling I have been called. There is no dispute.
Date and time, yes, I am disputing. Without the records, I cannot agree. Even in the representation, he has not mentioned that he was called for counseling. He said, I did not go for counseling.
Now, how that is relevant? Even if petitioner was not called for counseling, but if he or she, if her merit position brings her to the zone of consideration, then why you will disallow him considering the plight of the petitioner? She has lost the job in a selection process which was conducted by the commission. At least that sympathy you should show.
Supreme Court did not say that. Supreme Court.
Whether the Supreme Court has debarred these candidates to participate in
No, not specifically, but
SLST 2016 upper primary.
the openings which the Supreme
Rather, Supreme Court has said that those candidates who are working in different departments of the government, they can go back.
Yes, so I'm agreeing. I'm here. That is what I'm trying to
So
distinguish.
here the court, when the candidate has participated in the selection process, came within the, if court proceeds on the premise that candidate comes within the zone of consideration, then why petitioner will not be permitted to participate in the counseling? In view of the specific observation made by the Supreme Court in in connection with another batch of candidates who leaving their jobs in different government establishment have joined the post of assistant teachers and they are permitted to go back to their own position if they are not tainted candidates.
Here the candidate got the opportunity, but The candidate did not participate in the council.
At that point of time, petitioner was working.
No, that you'll sit tight when the opportunity comes. You know that you were not working peacefully. You knew that your job was at stake. There was a very marginal chance of the order being reversed in the appeal.
Issue. Affidavit of service filed on behalf of the petitioner.
Start on the vacancies. This much homework my learned friend has not done. Let me ascertain whether there are vacancies in this pure science Bengali medium school in general category.
Affidavit of service filed on behalf of the petitioner is taken on record.
Without a